Welcome to the Taxpayer Podcast, a podcast production by the Taxpayer. Each of our episodes is CPD certified. To claim your CPD points, please visit our website. For more informative discussion on tax law, please visit our website to learn more about the Taxpayer Journal.
Peter, nice to see you again.
Trevor.
Can you believe that it's 2026 and it's almost the end of February?
And the budget is tomorrow. See what that brings.
Oh, I didn't even realize that.
That's tomorrow.
Oh, well, here we are. It's our first podcast of 2026, and we'll try and keep it up regularly. And, I think both of us enjoy it, so why not? Shall we start off by discussing the purpose test in the GARD, the General Anti-Avoidance Rule, Section 80A, and perhaps I should read it. Section 80A reads as follows. Bear with me while I just find it. It says, an avoidance arrangement is an impermissible avoidance arrangement if its sole or main purpose was to obtain a tax benefit. And people latch on to that word "its," the avoidance arrangement's its purpose was to obtain a tax benefit. And so some people, and fairly respectable people as well, now you hear them saying that the test is objective. Certainly in the old days, under the old Section 103(1), Judge Corbett gave judgments in the Gallagher case where he said it has to be subjective, otherwise there'd be no difference between effect and purpose. And the debate rages on, and it sort of raised itself again. There's a tax court judgment which is published on Safley, and I, in my wisdom or lack thereof, decided not to report that case in the Taxpayer because it's very long, and I know that leave to appeal to the SC has been granted. So rather wait for that judgment to publish. But I did take the liberty of writing something about just on an extract, because the judge there talks about the purpose, and he quotes from Silk and various other sources and talks about, I can't remember quite how he characterizes it, but it's sort of partly objective and partly subjective, which to me just sounds like nonsense. To me, it reminds me of one of the judges said about capital or revenue, that something's either capital or it's revenue. There's no halfway house in between, and I think it's the same thing with purpose. We've discussed this before and we've written about it before, but it still seems to be a live issue. And the one thing that occurred to me in writing about it recently, and can I interrupt myself and give a little advert for this book, which has just been published? It's called 101 Tax Quotes. It was to say thank you to all our loyal subscribers and to mark the 75th year of the Taxpayer. This year is 75 years of the Taxpayer. So we produced this and sent it out gratis to all of our subscribers to the print edition. And I must say I had such fun putting it together. And so I admit that I'm very subjective about it and of course biased, but I think it's absolutely fantastic. I haven't written it. These are just quotes that I've put together from other people, but I find it so useful. That's its real advantage is, it's a little bit entertaining and all of that, but it's a very convenient list of authorities. And when you're writing I did a tax opinion the other day, and I quoted 3 extracts which happened to be in here. I didn't quote them because they were in here. They just happened to be in here. Anyway, one of the extracts here is from the Constitutional Court judgment in the case of University of Johannesburg versus Auckland Park Theological Seminary. And it's a 2021 Constitutional Court judgment. And the court unanimously held as follows, and it's to do with interpretation. And of course, we know there are lots of cases like Endumeni and Coral Lagoon and et cetera, which say that statutes must be interpreted so as to be consistent with the Constitution. But what is the position when it comes to a contract? The thing about this case, they're interpreting a contract. And if I can just read from it, he said, the Supreme Court of Appeal has explicitly pointed out in cases subsequent to Endumeni that context and purpose must be taken into account as a matter of course, whether or not the words used in the contract are ambiguous. A court interpreting a contract has to, from the onset, consider the contract's factual matrix, its purpose. And that's what leapt out at me. The contract's purpose, just like the avoidance arrangement's purpose. The circumstances leading up to its conclusion and the knowledge at the time of those who negotiated and produced the contract. And he goes on to say, this means that the parties will invariably have to adduce evidence to establish the context and the purpose of the relevant contractual provisions. And to cut a long story short, I think when the judge there says its purpose, the contract's purpose, or when the Section 88 talks about its sole main purpose, the arrangement's purpose, that's a metaphorical use of language. The contract doesn't have a purpose. A judgment, and in the Capitec case, the Constitutional Court said, this judgment concludes that SARS should not have disallowed the assessment in its entirety. Well, a judgment doesn't conclude something. It's just a metaphorical way of saying the judges who wrote the judgment concluded in their judgment that the following is the case. And it must be the same thing with an arrangement, etc. So one mustn't go overboard on that. And to my mind, the test has to be subjective. Now, it's always been part of our law from ITC 1185 and the Smith case in relation to farming, that when you determine a subjective purpose, you do have regard to objective factors. Like you don't just take the taxpayer's ipse dixit, you interrogate the objective facts just to see whether those things actually support what the taxpayer says his or its intention was. But at the end of the day, the test remains subjective. That's my view. What do you say, Peter?
Yeah, I agree with that, Trevor. And just a couple of points I think that are worth mentioning here. Maybe the first one is that, as you say, it's always been a subjective test, and the test has been around for a very, very long time. I was going back into the history, the dark history, not dark, but the dusty history books around our income tax law. And in 1959, the GAR provision there referred to the sole or one of the main purposes. So that was certainly a difference. But it talked about, again, the purpose of an arrangement, the sole or one of the main purposes of an arrangement. And it was held in respect of that provision that it was subjective. That was the old Section 90 before any of us were either born or started practicing. So it's consistently been held to be a subjective test. And then a lot has been made by SARS, and in this case as well, about, as you said, Trevor, Section 103 referred to the subjective purpose of the taxpayer, and Section 80A refers to the purpose of the avoidance arrangement. But I completely agree that you can't look at the arrangement. The arrangement doesn't have a purpose. Point one. Point two, look back at our law to the 1950s where we had similar wording to what we currently have, and it was a subjective test then. And then what is really interesting for me, and it's a bit of a side point, but I wanted to raise it here, is we've talked previously about the multilateral instrument, and that is the instrument that basically introduced the base erosion profit shifting provisions of the OECD into a lot of our double tax agreements. And one of its provisions talks about the fact that if you enter into a transaction in order to obtain a benefit under a tax agreement, then you don't get that benefit. And the wording that's used is purpose. So it talks about if your purpose or one of the purposes of entering into the transaction was to obtain a benefit under the double tax agreement, then you don't get that benefit. So, and they talk about the purpose of the transaction, very similar to Section 80A, purpose of the arrangement. And the OECD brought out guidance on this, and they said that test of purpose in the context of the MLI is a subjective test. So that for me is very powerful. We've signed up to that. The OECD has spoken. It has talked about purpose in a very similar context, the purpose of a transaction, in our case, the purpose of an arrangement. And it said unequivocally that it is subjective. So there you have some, for me, very strong persuasive authority in relation to relation to this aspect. And the other point, Trevor, just to make is that can you believe it's been 20 years since Section 80A replaced Section 103? 20 years, and we're still talking about this. I think it's a shame in a way that we haven't had clarity long ago on this point.
It's taken a long time for any cases to get to court.
Oh,
But to me, I think that what you've just said is a very, very powerful point. And the fact that South Africa signed up to that.
mm,
And then if you take the judgment of Bilchitz in the Thistle Trust case, he said and also Madlanga gave a judgment saying that you must interpret things holistically, so that the law makes sense, and it must be rational and it mustn't be arbitrary. Now, all of that points to exactly what you're saying. It confirms what you're saying.
And if I can just rant on a little bit more about that case that you mentioned there, Trevor, because there was also, for me, a misinterpretation of the concept of tax benefit. And tax benefit, there's so much good law on what a tax benefit is. You've mentioned Smith's case, 1960s, alluded to in Sasol Oil, the case on simulation as well. And for there to be a tax benefit, a party needs to sidestep an anticipated tax liability. So you say if the taxpayer hadn't entered into the transaction they actually entered into, what alternative transaction would they have entered into? And would that alternative transaction have resulted in tax? If so, there's a tax benefit. A simple example for me is you've got a company that holds shares in another company, and the shareholding company is going to sell its shares to a third party. And then someone says, no, don't be crazy. That's going to give rise to capital gains tax. Rather do a buyback. So the company in which you hold the shares buys back your shares, then you get a nice tax exempt dividend. That's a perfect example of a tax benefit, because they enter into the buyback transaction and you say, if you hadn't entered into that transaction, what would you have done? The answer is, I'd have sold my shares and I'd have paid CGT. That's a tax benefit. But you can't postulate 100 counterfactuals like, why didn't you do this or why didn't you do that? It's simply, what did you do? And if you hadn't done that, what would you have done as a factual matter? And I don't know, it just seems to get very confusing when you read some of the judgments on this stuff. We've got good law on this.
Yeah. So what's the answer in that case? If someone says rather buy my shares back and give me a dividend, is that a tax benefit?
I think it's a tax benefit. And then you say, but on the purpose, my purpose was to cash out, to get cash instead of holding the shares. And in terms of Conage, I can enter into my transaction in a tax efficient way. So I think you tick tax benefit. But when it comes to purpose, you say, my purpose is to, achieve a commercial goal in a tax efficient way. But if you go to an objective test and purpose, who knows where you might end up, because I'm talking about my purpose as the tax-paying company. So, but hopefully the Constitutional Court must just give us a nice judgment and
Absolutely.
the GMK and other matters that they're hearing.
Oh, we look forward to that.
Yeah.
But I seem to remember that Judge Sutherland, in the ABSA case, he gave the High Court decision. Remember, he spoke about a semantic gyration, can't turn a Nazi into an orange. I love that comment. But we also refer to the fact that dividends are exempt is so banal, it could hardly be a tax benefit. I mean, it's just an everyday event, If you put your money in your cupboard because you don't want to earn interest and pay tax, I mean, there's nothing there to tax. Anyway, we're rambling now.
Is that quote in the book, Trevor?
Which is the Nazi one?
Yeah.
Yes, it is.
Ah, brilliant. There's a spoiler alert.
It's definitely there, yeah.
I have been reading
Um,
some of the quotes, and what struck me, Trevor, is the beautiful eloquence of our judges over the years as well. And they really put things so beautifully, and they capture such central legal truths, but they do it in this beautiful, eloquent,
yeah.
and sometimes very funny way. I love it.
And there's the one, if I may be permitted, I love this one here. This is Sidney Kentridge said this in a lecture at Cambridge University. Quote, Lord Justice Asquith, later himself a law lord, once described the qualities of an ideal trial judge. That judge, he said, was expected to be quick, courteous, and right. This did not mean, he added, that the Court of Appeal was to be slow, rude, and wrong, for that would be to usurp the function of the House of Lords.
I did read
Yes,
that.
yeah.
Yeah.
I seem to remember on a recent podcast, I think it was our previous one, mention was made of the fact that um, the idea of a substantial understatement in section 221 to 223 of the Tax Administration Act. If you look at the understatement penalty percentage table under the various categories of behavior, one of them is substantial understatement. And that carries the standard case 10% penalty, 25 and 0. Now, is the protection obtainable from a favorable opinion from a independent registered tax practitioner? Does that protect the taxpayer only from that category or not? So that point, I think you made the point, and it took me a little bit by surprise because I hadn't thought about it. But then I saw there's a definition of substantial understatement in section 221, which says, in this chapter, unless the context indicates otherwise, the following terms, if in single quotation marks, have the following meanings. And substantial understatement means a case where the prejudice to SARS or the fiscus exceeds the greater of 5% of the amount of tax properly chargeable or refundable under a tax act for the relevant tax period, or 1 million rand. So it's that defined meaning, which I think applies to section 223, 3B, which talks about the protection. So I think it covers all of the categories of behavior, not just the one.
Another point on that, Trevor, on the 223, because it's a fascinating section in a way. And one of the other points I think that's important is that the tax opinion is received in the year in which the tax return goes in and prior to the end of that year. So I think that timing is really important as a practical matter. And then the other really interesting part is that there needs to be certain language, it's called the 223 language, and that's that the registered tax practitioner has to say that in his or her view, it's more likely than not that if the matter proceeds to court, the views expressed in the opinion will be upheld. So the question is, what's more likely than not? I mean, I think say more than 50% probably, but you need to sort of express the view in the opinion. But it relates to the position that the taxpayer will take in his or her tax return. And I think that's quite important because often in an opinion, you debate a point backwards and forwards in your opinion and you end up with sort of, a view. But I think to have a 223 opinion, you need to be quite specific and say the taxpayer is going to, in his or her tax return, state that this amount is of a capital nature and not of a revenue nature. And it's in relation to that disclosure that I think, in my view, that is more likely than not correct and will be upheld if it proceeds to court. So I think there's a lot of nuance around these 223 opinions and a really important part of our tax law now. So I think I think it's a very good point that you made as well. And I think it's just worth unpacking the whole section and kind of how it applies, because I think it's a very powerful tool for taxpayers and penalties. You don't want to sit with penalties on top of tax and on top of interest.
Absolutely. Also, in this little book, this little very useful book, there's an extract from the judgment of Acting Justice Chaskelson. That's the son of the former Chief Justice in the Thistle case. And I'm not a great fan of his judgment, but this aspect on penalties is very good, because what happened was the taxpayer, the Thistle Trust, had relied on an opinion of Marevitz, who was long deceased. And in his opinion, Marevitz had pointed out that SARS didn't agree with what he said, but he thought SARS was wrong. And they relied on that. And SARS actually argued in the Constitutional Court that SARS argues that if Thistle had taken reasonable care in completing its return, it would have ignored the advice given to it and followed the stated SARS position, which that advice expressly considered and rejected. And then the judge said the following: This argument is based on the proposition that no taxpayer can act reasonably on advice that differs from SARS's statements of its interpretation of tax legislation. That argument would elevate SARS to the status of an authority that can decree the only reasonable interpretations of tax legislation. It is an untenable argument. In other words, it's nonsense. Yeah. Okay, then the other thing I thought we could talk about is test cases. And it's not something I've dwelt on particularly before, but I thought it was time to have a look at it. And why that was the case was I've just heard on the grapevine that there were a lot of ETI, which stands for Employment Tax Incentive cases, where apparently I had heard from someone who was involved in the case, but he didn't particularly discuss it with me, that the one case he's involved in has been designated as a test case, and then a whole lot of other objections or assessments have been what's the term? They've been stayed pending the outcome of that. And that whole system seems to me to be completely flawed. But it's dealt with in Section 106.6 of the Tax Administration Act, and it says that a SARS official can designate an objection or appeal as a test case, stay the other objections or appeals by reason of the taking of the test case on a similar objection or appeal before the tax court. And then that must inform the taxpayers accordingly, and the notice must set out the number of common issues, the questions of law and fact, and the importance of the test case. Then the taxpayer whose appeal has been designated a tax case can object to that and ask SARS to withdraw it, and they can withdraw it. But SARS can also, and the taxpayer can use Rule 52 to go to the tax court. And then the tax court can say, no, this must go ahead, and can designate what the issues will be. And it just struck me, what happens to taxpayer confidentiality in that situation? And I find in the rules and in Section 106 of the Tax Administration Act, I don't see anything which says that the taxpayer must agree to it. But now there's a judgment that's come out, and when I expressed certain views on test cases, I hadn't read that judgment. I read it fairly recently. And it's the judgment of Judge Marley. And he says, and I've got his judgment in front of me here. He says that SARS wished to amend its case and to rely on a definition of the word work, which they hadn't relied on before. And the taxpayer objected and said, no, that's now a new case. And in terms of Rule 31.3, SARS can't do that. And the court upheld that. And my paraphrase of his judgment is the following: while SARS had attempted to characterize the amendment as merely raising additional legal points, in substance it introduced a material and new dimension to the case. It sought to recast the meaning of work, in inverted commas, by importing statutory definitions not previously relied on, and it challenged the nature of the employment relationship by reference to new legal criteria. The taxpayer's contention that this was a novation was not without merit. SARS was not simply elaborating on existing arguments, it was shifting the interpretive network of key statutory terms which went to the heart of whether the ETI claims had been validly made. And then he went on, and then he says the 408 taxpayers had the other 408 taxpayers. I was flabbergasted to read that there were 408 other taxpayers whose cases had been stayed pending this tax case. That's a huge number of taxpayers. Had agreed to be bound by the outcome based on the originally pleaded case. Where does that come from? I don't see anything in the rules or the legislation which says you must agree to it, but the judge says so, and had not been given notice of the new issues in the statutory provisions. And he said it would be fundamentally unfair and not in the interests of the administration of justice and potentially unconstitutional to bind those taxpayers to an outcome based on grounds they were not afforded an opportunity to address, and so on. So that just illustrates. So what's going to happen with that test case now, heaven alone knows. I suppose they'll have to argue it on what they originally did. But the assumption seems to be that the facts in all the cases that are stayed, and there are 408 of them, are the same as the test case. And the judge in the tax court, if you oppose it, can say that, how can the other people whose cases have been stayed be bound by what is found in another case? Normally, a tax court decision is not binding on anyone except the parties to that particular dispute. The whole thing is a mess. Anyway, I don't know if you've come across those ETI.
Let alone the quality of the counsel. I mean, yeah, you don't get a chance to produce your own witness. Let's say the taxpayer in that test case had a really poor witness. They were just really poor on the stand. And assuming the facts are the same, the facts are never always exactly the same, and slight differences in facts, but a huge difference in the outcome. But if somebody's strong under cross-examination, Trevor, I mean, that's where you win or lose cases. So now you beholden to this witness that you don't know who this person is and whether he or she is good or bad under cross-examination, and you can't decide which witnesses to call and which not to. It's nuts, eh? And to answer your question, so I've been involved in a multitude of transactions where not 400 or whatever, but where a number of taxpayers, normally 5, 6, 7, normally pretty sophisticated taxpayers, are involved in entering into very similar transactions, never exactly the same, but very similar transactions. And SARS decides that they don't like the transaction, so they go after all of the taxpayers. I've never seen SARS use this test case principle. Never. They tend to accelerate the one case, and it often is the case where they think the facts favor them the best, and they push that case along. And then the other ones, you just get these responses from SARS, those kind of standard responses where they say, "We'll keep you updated with your audit, but nothing has progressed." And then there's one taxpayer has been chosen, theirs accelerates along, and they actually, one case ended up in the tax court last year. Still waiting for judgment. It was heard in May, still waiting for judgment, but that's another story. But so de facto, I think SARS often choose a test case, but they don't use these provisions, for following that case through. And now you can maybe see why.
And what about Section 34 of the Constitution, which says everyone, and I emphasize the word everyone has the right to have any dispute that can be resolved by the application of law decided in a fair public hearing before a court or, where appropriate, another independent and impartial tribunal or forum. That can't mean using some other taxpayer as your proxy. That means you.
Yeah.
Yeah.
It's super interesting.
Yeah. So I don't know. We'll wait and see what happens, but
Yeah.
I think
Wow.
that test case, those rules are a bit flawed, as is that.
Okay,
I think
for sure.
taking something out of some other jurisdiction's legislation and plonking it in our act and not thinking through the consequences.
And
These
kind
are
of,
sorry.
I was going to say, and sort of saying it seems like a good idea because you've got 400. You don't want to run 400. Let's run one. So you can see sort of the sort of very base logic there, but you can't bind other people to that one case. I mean, that doesn't make sense.
And I've got enough insight into a few cases to know the facts are radically different.
There you go.
Absolutely. No comparison.
There you go.
Some are absolutely vanilla, and others, people are trying to take a chance.
And isn't that always the case too? I mean, in life, generally. So, interesting.
Yeah.
So
Okay.
we'll do this again soon, Trevor. As I say, the budget's tomorrow, so maybe there's something exciting and we have to jump on and do another one. But yeah, look forward to our next discussion.
And on the solar main purpose test, one of in that United Manganese of Kalahari case where there were 5 taxpayers, one of them, the ABSA case, was heard last year by the Constitutional Court, and so we can expect judgment. I don't know when. They have an elaborate process before the judgment comes out, but maybe by the time we talk again, we'll have a judgment from the Con Court on this topic, and then we can discuss it all over again.
Certainly on tax benefit, that they're going to definitely, that's definitely part of their judgment. And I hope at least Obiter that they discuss and give a view on the solar main purpose, and in particular the subjective or objective nature of it, Trevor. So here's hoping.
Yeah. Okay, well, let's listen to the wireless tomorrow, and we'll see what's new.
Absolutely.
There's always something new, isn't there? That's the thing about the subject of tax.
Yeah.
Spoke to someone the other day, just submitted a dissertation for the Master MCom in tax at UCT, and is, so glad to have finished the coursework and submitted the dissertation. And I couldn't resist saying, you must understand that's just the beginning. Tax is changing all the time. So if you don't stay with it, you lose it. Anyway, these chats that we have every 6 weeks or so are our way of trying to stay with it.
Absolutely. Thanks, Trevor. Speak soon.
Oh, thanks, Peter. Bye-bye.
The Taxpayer is hosted by the editors of the Taxpayer Journal, Trevor, Emslie, and Peter Dachs. For more information on our journal and other products, please visit our website at taxpayer.co.za. Each of our episodes is CPD certified. To claim your CPD points, please visit our website. Thank you for listening to the Taxpayer Podcast. You can find more episodes on your favorite podcast platform or on our website at taxpayer.co.za. Please like and subscribe on YouTube and rate our podcast on your podcast platform of choice.